What's up, guys? I wanted to talk to you today about something that I've noticed on uh, YouTube is that right to travel videos are getting increasingly more and more popular. And it's something that's been increasing for, I don't know, the past 6 months to a year. It's really started to grow in popularity. There's a lot of channels out there that's putting out right to travel content and all that stuff. And this is something that I first learned about 10 years ago, something like that. And I didn't look into it too deep until a couple years ago, and then most recently I've been working on a case. Someone's filed against me for an accident that I was in a couple years ago, and they're claiming additional depreciation value, damages, blah blah blah. Anyway, so working on that, I've discovered that Cornell Law is a great website to utilize for law resources, for legal resources, and great tool. Cornell Law University, Cornell University. They're a good, reputable source. So I just wanted to look at some stuff here with you on right to travel. What does the law actually say on right to travel? So let's go to Supreme Court. And let's go down here to Archive of Decisions. And let's just do historic by topic. And we're going to go right here, right to travel. And let's click on it. If it'll click, there it goes. All right, there's all our Supreme Court decisions. One from 1958, 1964, 65, 66, 69, 70, and 71. So let's look at this first one from 1958 and see what the ruling was on the right to travel. Let's just see here. Now hold on one second. Alright, so this one pertains to 2 applications for passports denied by the Secretary of State. Okay, so that's not the one we want. Alright, so let's look at this one from 69. So these 3 appeals were restored to the calendar for re-argument. Okay, so right here, it was ruled on by the Supreme Court that the constitutional right to travel from one state to another occupies a position fundamental to the concept of our federal union. It is a right that has been firmly established and repeatedly recognized. So, a firmly established right to travel, the constitutional right to travel from one state to another. And just above that, in number 16, it says, we have no occasion to ascribe the source of this right to travel interstate to a particular constitutional provision. It suffices that, as Mr. Justice Stewart said for the court in the United States versus Guest, Interesting. And in number 15, just before that, it says, for all the great purposes for which the federal government was formed, we are one people with one common country. We are all citizens of the United States, and as members of the same community, must have the right to pass and repass through every part of it without interruption, as freely as in our own states. And just before that, it says, this court long also recognizes that the nature of our federal union and our constitutional concepts of personal liberty unite to require that all citizens be free to travel throughout the length and breadth of our land, uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. That proposition was early stated by Chief Justice Taney in the passenger cases. Right there, you can look it up. And number 18 says, when talking about the constitutional, from 17, the constitutional right from one state to another, the right finds no explicit mention in the Constitution. The reason it has been suggested is that a right so elementary was conceived from the beginning to be a necessary concomitant of the stronger union the Constitution created. In any event, freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. And check out this ruling. If a law has no other purpose than to chill the assertion of constitutional rights by penalizing those who choose to exercise them, then it is patently unconstitutional. And that's the Supreme Court ruling. Or that's the case that was derived from. That's interesting. So in 25 of this case, the ruling is that the right to travel freely to and from the state of Georgia and to use highway facilities and other instrumentalities of interstate commerce within the state of Georgia. Within. Interesting. And that's interesting. The constitutional right to travel from one state to another and necessarily to use the highways and other instrumentalities of interstate commerce in doing so occupies a position fundamental to the concept of our federal union. It is a right that has been firmly established and repeatedly recognized in Crandall versus State of Nevada. And in 27 it says, for all the great purposes for which the federal government was formed, we are one people with one common country. We are all citizens of the United States, and as members of the same community must have the right to pass and repass through every part of it without interruption, as freely as in our own states. And hold on. Yeah. And it back down here. In any event, freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. See Williams versus Fears. And this in Edwards versus People of the State of California, it says, invalidating a California law which impeded the free interstate passage of the indigent. The court based its reaffirmation of the federal right of interstate travel upon a commerce clause. This ground of decision was consistent with precedents firmly established that the federal commerce power surely encompasses the movement in interstate commerce of persons as well as commodities. See, it's talking commercial. It's all commercial. But, oh, goodness. So back to the main page. Alright, so let's come down here to constitutional law. Let's learn about some constitutional law. You know, it's a broad topic. Blah, blah, blah. Yes, we know. I found all this stuff very interesting because it explains how the Constitution it gives the government powers, you know, like Article 2 establishes the presidency and the executive branch of the government. The powers of the president are not as clearly enumerated as those of the Congress. He's vested with the executive power by Section 1, and Section 2 establishes him as the commander-in-chief and grants him power to give pardons except in cases of impeachment for offenses against the United States. And Section 3 provides the power to make treaties with the advice and consent of 2/3 of the Senate, and the power to nominate ambassadors, ministers, judges of the Supreme Court, and all other officers of the United States. Then it tells the role of the Supreme Court and the rest of the judicial branch of the federal government is covered by Article 3. And you can read about that in Article 3. This kind of explains what all the different articles of the Constitution, what they mean. So this is interesting. Article 6 of the United States Constitution states that the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or shall be made under the authority of the United States, shall be the supreme law of the land. This is commonly referred to as the Supremacy Clause, and you can go and read about that. I've already read it. It's pretty cool. It basically says that the Constitution is the highest law of the land. So all the articles and amendments, they apply as the highest law. Furthermore, all federal, state, and local officials must take an oath to support the Constitution. Okay? The Constitution is what secures our rights. Everyone who works for the government has to swear an oath to support the Constitution, to uphold it and defend it against all enemies, foreign and domestic. So help them God. It's an oath to God that they swear to protect our rights and uphold our rights. So check this out. This means that the state governments and officials cannot take actions or pass laws that interfere with the Constitution. Laws passed by Congress or treaties. The Constitution was interpreted in 1819 as giving the Supreme Court the power to invalidate any state actions that interfere with the Constitution and the laws and treaties passed pursuant to it. The power is not itself explicitly set out in the Constitution, but was declared to exist by the Supreme Court in McCulloch versus Maryland. So, this means that state governments and officials can't take actions or pass laws that interfere with the Constitution. So, if the Constitution says I have the right to travel freely without being interfered with, without interference from the government, without being hindered from the government, any state or governmental agency, like the cops, then how can the state make a law that requires everyone to have a license to travel upon the roadways, to drive, because they call it driving. You're not traveling, you're driving on the roadways. Because driving, it denotes commerce. If you look at the definitions and you read the law and then you read the definitions, the legal definitions, not the Webster's definitions, the Black's Law definitions, because that's the definitions they go by. They have to go by legal definitions. You look up those legal definitions, and it applies to corporations doing commerce. Now, they even say, here's the interesting thing, is that, they even say people and natural persons. It applies to any all corporations or natural persons. But you look up the word person, and it means corporation or individual. You look up individual, and it means corporation. And it means natural person or person and natural person. So you look up the word natural, and it means of the earth. But, oh yes, and another definition of person or natural person, one of their definitions of natural persons is a human being, okay? If you look up the word human being, there is no definition. There's no legal definition for human being. So you can't have a word where there's no definition of it. If you don't define the word doesn't, it's not valid. It's an invalid word. So we're not human beings. What we are is we are men or women or children. And the interesting part about that is that in the law dictionary, there is no definition for man, woman, or child. And there's no definition for human. And so that puts all their definitions of person or natural person as a corporation. They never say a living flesh and blood man or woman, but it's always person or individual, and or even natural person. And it's all those definitions are corporations. They don't define, and if it's not defined, then it's open for interpretation, and therefore it's not legal. Legal stuff has to be defined definitively. So their laws, all the laws that they have out there, these state laws, they're all to regulate commerce. Because if you go back to here, to the first part of this, it states that that state and governments only have the right to regulate commerce. They don't have the right to regulate people in the course of their lives, freely doing what they want to do, I'm pretty sure it's right here. It could have been under that other part that I was at, but we're almost at 18 minutes here. I just wanted to make a quick video. It's pretty easy to do research as long as you go to the right sources. You can go to your individual state website, state government website, and they've got all their laws and stuff on there. Look up their laws, see what they say. Look up the traffic laws and see how it's worded and who it applies to and all that stuff, and see if it applies to you. If you're not driving on the highway for commerce, if you're not being paid every time you're driving your vehicle, then you don't need a license for that. If you're just going to the store to buy food, or you're going to work, or you're traveling across the country, you're not for hire, you're not being paid, then no license is required for that. So here's a list of rulings. The right of the citizen to drive on the public street with freedom from police interference unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by the courts. And another one in Wingfield versus Fielder says the right to use the use of the automobile is a necessary adjunct to the earnings of a livelihood in modern life requires us, in the interest of realism, to conclude that the right to use an automobile on the public highways partakes of the nature of liberty within the meaning of the constitutional guarantees. And in Chicago Coach Company versus the City of Chicago, the court makes it clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of business enterprise or adventure with the corporate state, no license is required of the natural individual traveling for personal business, pleasure, and transportation. Adams versus City of Pocatello. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways, transporting his vehicle and personal property for either recreation or business, but by being subject only to local regulation, i.e. safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurance. And the 14th Amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person with its jurisdiction the equal protection of the laws. So, food for thought. Let me know what you think. Peace.